Hi, I'm Susan Lipp, Editor-in-Chief of Trust and Estates. I'm here this morning at the Heckerling Conference with Dana Fitzsimons, who is Senior Vice President at Bessemer Trust. And Dana also writes a fiduciary update column for Trust and Estates. So Dana, can you tell us a little bit, what were the hot decisions in 2013 regarding fiduciary law?
So, good morning. Thanks for having me. It's actually been a really interesting year. I review the cases every morning from all over the country, and every single year we do a recap of the cases. And I think every year that there'll never be another year as good as last year's cases, and this year was no exception. There'll never be another year as good as this year's cases. There's been fiduciary development all over the country on a lot of hot issues. Let me just touch on some of them. First, in the area of decanting. Decanting statutes have become very popular. This is the ability of a trustee to exercise its power to make discretionary distributions, to put the assets into an entirely new trust, possibly with different terms. It's become a very popular tool for flexibility. Practitioners love it, fiduciaries love it, and there's been a lot of new statutes passed across the country. But we also had some case law action in the area of decanting. We had 3 cases. The Morse case out of Massachusetts, where the court said it would recognize the decanting power, but only on a case-by-case basis. And it would not give a blanket ruling that decanting was permissible at common law. There was a subsequent case applying Massachusetts law that refused to allow the decanting, and a New York case that refused to allow decanting. Those are the Ferry and Schreiber cases. And the reason that it was permissible in Morse but not permissible in these other cases is because in the later cases, the property interest of the beneficiary in the trust asset had vested. The beneficiary had a right to get the assets. That was the Ferry case out of Connecticut. And where the beneficiary has the right to the assets, you can't decant to take the assets away from them. But if you decant before the beneficiary's interests have vested, that might be okay. That was the Morse case in Massachusetts. So we had some decanting cases, which were interesting. Another area where we had 3 reported decisions, all taxpayer wins, is in the very important area of trust, taxation of trust income. As you know, the tax burden, the income tax burden on trusts is getting higher, in part because of the Medicare surtax and because of the higher income tax rates generally, and trusts are taxed. They hit the higher rate at a lower threshold. So clients are looking for efficiencies in the income tax burden on trusts. There were 3 states that argued for the rule that they could tax a trust income forever because the trust was created by somebody in that state. And this comes up in Illinois, New Jersey, and Pennsylvania. And in all 3 of those cases, the trust had been moved. The trustee was somewhere else, the beneficiaries were somewhere else, the revenue that the trust earned came from somewhere else, but the states took the position, all 3 states took the position that because the trust was created by somebody who was either domiciled or died in the state, that the state could tax the trust forever. And those were the McNeil, Kasner, and Lynn cases out of Pennsylvania, New Jersey, and Illinois, respectively. And in all 3 of those cases, the state loses, the trust wins, and on constitutional grounds, because there's no more contacts with the state, the courts say that the states can't tax those trusts anymore. A lot of people look at using the fiduciary power to change the situs of the trust to try to find tax efficiencies, especially now because the burden's getting so high, and these are 3 important taxpayer wins in that area. There are always surcharge cases. These are the cases where the beneficiaries are unhappy with the conduct of the fiduciary. They seek to get a surcharge award to punish the fiduciary for its actions. There were a lot of interesting surcharge cases this year. We can only touch maybe on a couple of them. There was a case called Matter of Strong out of New York, which is one in a series of cases we've seen going back to the Janes case out of New York that deal with a concentration of one stock, this being the very troubled Kodak stock that lost a lot of value. And the Matter of Strong case just continues the pattern of surcharge we've seen in those cases. No new ground really plowed there, but interesting. a more novel case out of New York, the Laudit case, involved AIG stock, a concentration of AIG stock that lost a lot of value, as you can imagine, as part of the economic collapse. So here's where this gets interesting in the Laudit case. The trusts were created in either Massachusetts or North Carolina, and they had a clause that protected the trustee, an exculpatory clause, which elevated the burden of the beneficiaries if they wanted to surcharge the trustee. And so you had Massachusetts and North Carolina trusts. Some of them were GRATs that failed, meaning that the assets didn't appreciate over the required payments from the GRAT. So the GRAT didn't transfer any wealth to the next generation because the stock, which was AIG stock, went in the tank. Mm-hmm. And when that happens, a GRAT doesn't work. And you had other non-GRAT type irrevocable trusts as well. So here's where it gets interesting. The trusts have lost a lot of value. The beneficiaries, you can imagine, are unhappy about it, and they want to sue the trustee. The trustee petitions in New York, it's a corporate fiduciary, petitions in the New York court to settle its accountings, which is a way of forcing the beneficiaries to bring their claims now. Mm-hmm. The beneficiaries take the position that because the suit was brought in New York law will apply. Under New York law, the exculpatory clause would not protect the fiduciary because New York takes a negative view of exculpatory provisions. But in North Carolina and Massachusetts, the clause would protect the fiduciary. Mm-hmm. The court in New York says that the choice of law provisions in the trusts will control and will apply North Carolina and Massachusetts law rather than New York law, regardless of the fact that the suit was initiated in New York. And the reason that the court enforces the clauses is because the court finds that there is a connection between those states and the trust. It's not an arbitrary selection of forum. Mm-hmm. Therefore, the New York court applies Massachusetts and North Carolina law, enforces the exculpatory clause, and the fiduciary is held not liable. So that's an interesting case.
Dana, I think we're running out of time, but I know that you're speaking on Wednesday, and I think you'll be covering these issues in a lot more detail.
We will. We'll get into, very briefly, a lot of areas, the nature of fiduciary duties where you hold a business interest, whether an arbitration clause is enforceable in a trust, the nature of settlements, and a whole lot of other interesting areas, the standards for discretionary distributions, and there's just been a ton of activity this year, a lot to talk about, and we're going to have a great program.
What time is it on Wednesday?
I should know the answer to that, and I don't, but it's in everybody's materials.
Okay.
She got me with a trick question.
Okay, I'm sorry about that, but I'm sure people will want to hear what you have to say on Wednesday, and thank you for providing us with that recap.
Happy to do it.